I have apologies from Deputies Wallace and Daly. This meeting has been convened for consideration of committee stage of two bills, the first of which is the Court's Establishment and Constitution Amendment Bill 2018. Before we begin, members are reminded of the long-standing parliamentary practice to the effect that members should not comment on, criticise or make charges against either a person outside the Houses or an official, either by name or in such a way as to make him or her identifiable. I also remind everyone to please switch off their mobile phones as they interfere with the sound recording equipment. We are joined by Deputy Charles Flanagan, Minister for Justice and Equality, and his officials, and I welcome you all here this morning. There are no proposed amendments to the bill, so I would at this point ask the Minister if he would like to make opening remarks before we address the sections. Minister.
Thank you, Caoimhghín, and thanks to yourself and your members for scheduling this short but nevertheless important piece of legislation for this afternoon. I'm joined by officials on my right, Richard Fallon, on my left, Patrick McHale, and the bill, as members will be aware from second stage, deals with the amendment of Section 1A of the Court's Establishment and Constitution Act 1961, dealing with judicial resources. The purpose of the amendment is to amend subsection 2 of the 61 Act, providing for the increase by 6 from the current 9 to 15, the maximum number of ordinary judges of the Court of Appeal. This amendment will achieve the primary purpose of the bill as initiated.
Minister, fine, thank you. I propose to proceed into the sections. Is it relating to a section?
No, it's just general.
A general remark? Well, by all means, go ahead, Deputy.
First, I suppose just to welcome the bill. There's a significant backlog in the Court of Appeal, so obviously it's welcome that that's being addressed. We will be supporting this bill. We don't have any amendments, and I'm not sure that we will at report stage either. Just, I suppose, on a related matter that's relating to the courts and the judiciary and all the rest. The Judicial Council bill proceeds to report stage, I think, this week in the Shannon. Do you have any sense when it might reach second stage in the Dáil, obviously pending passage of that, and this committee? Do you have any timetable for that?
Yes, it is my intention to commence report stage of the Council bill tomorrow afternoon in the Shannon. With cooperation, it may well be possible to complete report stage tomorrow, whereupon I would be keen to contact the Business Committee with a view towards commencing second stage in the Dáil. What I propose to do, as I don't have proposed dates with me, but I would be happy to have contact made with opposition spokespersons O'Leary and O'Caoláin immediately after this meeting, in order to ascertain your views on the matter. We have the remainder of this week, Caoimhghín, and 3 weeks, and again it would be my desire that we could schedule committee stage of that bill during the course of those 3 weeks. But again, I would be in the hands of the committee. There is a public sense of urgency in relation to that legislation. It is one of a number of priority pieces of legislation, but I understand the committee has its schedule of business. It certainly wouldn't be my intention either to interrupt or disrupt that. So I would be keen to make contact with you in advance of tomorrow's report stage Shannon meeting.
Fine, Minister, and the committee will do its utmost to facilitate what you have requested. I propose to proceed now with the sections. There are no amendments, so I put the question that Section 1 stand part of the bill. Is that agreed? Caoimhghín. That Section 2 stand part of the bill. Is that agreed? Caoimhghín. The title. That this be the title to the bill. An Act to amend the Courts Establishment and Constitution Act of 1961 to increase the number of ordinary judges of the Court of Appeal to 15 and to provide for related matters. Is that agreed? Caoimhghín. As consideration of the bill has been completed, in accordance with Standing Order 90, the following message will be sent to the Clerk of the Dáil. The Select Committee on Justice and Equality has completed its consideration of the Court's Establishment and Constitution Amendment Bill 2019 and has made no amendments thereto. We shall now suspend briefly to allow for a changeover of Minister and officials. Caoimhghín Tara. Reform Amendment Bill of 2019. We are joined by the Minister of State at the Department of Public Expenditure and Reform, Kevin Boxer-Moran, and his officials. You are all very welcome. There are five, I beg your pardon, 5 proposed amendments, and I invite the Minister of State to make his opening remarks now, if he wishes.
I'm not making an open remarks.
You're not making?
No.
Thank you, Minister. So therefore I propose to proceed. Draw your attention to the grouping list, if the grouping list has been circulated. 1 and 3 are being taken together, 4 and 5 are being taken together, and the amendments 1A and 2 have been deemed out of order. The tablers have been appropriately notified. So we're going to take amendment number 1 in the name of Deputy O'Callaghan. 1 and 3 are related and will be debated together. So, Deputy O'Callaghan, would you like to address your amendment?
Yeah, I just want to say at the outset that I want to welcome the Minister and the officials in here. Obviously, the purpose of this legislation being promoted by Minister Moran is to try to provide greater protections for people who find themselves in the very unfortunate position that the financial institutions trying to regain possession of their property. And I think everyone here commends the Minister for seeking to improve the position that people have when they find themselves in that unfortunate position before the courts. So, as I mentioned in the second stage debate, we're supportive of this legislation I don't know to what extent it will have a significant impact on the position that people find themselves in, the unfortunate position when they're before the courts, but hopefully it will. I had put down a number of amendments, Chairman, which I believe would have improved the legislation in a number of ways. First of all, I think it's very important that people who find themselves before the courts have the benefit of having the legal protections available to them, advocated before the courts on their behalf. And that's why in one of the amendments I put down, I was seeking to, and I think Donnghaile put this amendment down as well, seeking to expand the parameters of the Civil Legal Aid Act so that it would apply to the applications that can be brought under this new piece of legislation. I also wanted to put forward an amendment that dealt with the situation in respect of a person who's applying for the appointment of a receiver. Now, the appointments of a receiver are very complicated aspects of our legal system. Generally, receivers are appointed pursuant to a deed of instrument or a contract, and the provision myself and Donnghaile had put down was to facilitate a change in the law so that a receiver couldn't be appointed over a certain type of housing property unless there was an order from the court. The final amendment I'd put down is in respect of what I think may be a bit of an ambiguity in the bill, which is that we would all hope, and I know the Minister would hope, that when this piece of legislation is enacted, it will apply to all existing mortgages and that it wouldn't simply apply to mortgages that are created in the future. Like, we have a problem in Ireland at present with people who have mortgages, they're in mortgage arrears, and it's them that this bill is seeking to protect, and it's what the Oireachtas should be seeking to protect. So I'd be concerned if in the future financial institutions were able to say, but this legislation doesn't apply to mortgages that existed prior to the enactment of the legislation. But listen, I had an opportunity to speak to Minister Moran last night about these amendments, and I'm conscious that if I push these amendments, that at best the legislation may be delayed, and at worst the legislation may not be enacted. And that's not what I want to do. My objective, and I'm sure it's Donnghail's objective, is to try to improve the legislation. But if there is that potential threat of the legislation not being enacted, well then I'm going to withdraw my amendments, Chairman, and that's what I'm saying to you here now. I think it is preferable if we get this legislation enacted. If it is enacted, I hope it will be of benefit to the house owner who finds themselves in that terrible position. I have some concerns, as I said, about the civil legal aid system, its application to it, and the appointment of receiver, and the extent to which it applies to existing mortgages. But if the courts interpret this legislation in a negative way once it's enacted, then we'll have to just come back and amend it, or else we may need to amend it in any event in due course. But because I want to see the legislation enacted without delay, I'm not going to pursue or proceed with any of my amendments.
Thank you, Deputy O'Callaghan. Deputy Donnghaile O'Leary, please.
Thank you, Chair, and I welcome the Minister and his officials here. This is a useful bill. I think there's an awful lot more that needs to be done in this area, but this is a useful piece of legislation. I suppose in relation to the ones that are in this grouping here, the first, I suppose just to speak to the section, first of all, I suppose section 2, like we had proposed in section 2, there's a huge issue, generally speaking, in relation to civil...
Sorry, Deputy, it's section 1 we're dealing with.
Okay, yeah, okay, sorry, the grouping, is it?
We're dealing with the grouping amendments 1
okay,
and 3,
okay.
but it is section 1.
All right, okay. In any event, I suppose, in a general sense, with regard to the bill, there is a significant issue in relation to legal aid across a wide range of actions, serious delays, excessive minimum contributions being asked, and that's due to an underfunding of the Legal Aid Board. In relation to these cases, this legislation will inevitably involve, I suppose, significant legal argumentation at the Circuit Court, where people will have to, I suppose, have the debate with the financial institutions and their legal teams. And I think it's only right and proper that people who don't have the means, which is very often going to be the case, where people are under mortgage arrears, should have access to civil legal aid where appropriate, in order that they can make strong arguments for themselves in court to be able to advance their case. I think that's only right and proper. That's been ruled out of order, but it is a matter that for, I suppose, the charge in the Exchequer and all the rest, but it is a matter that the Minister can bring forward himself at report stage, and the department can try to address. I think it is vitally important. In relation to the other amendments, amendment number 3 relates to a situation, and we had a meeting with FLAC there recently, and I think Deputy Caoimhghín would have also had communication with FLAC, and they are highlighting this issue, and I think they're correct. There are instances increasingly of people who have found themselves in situations that they had a mortgage. They were living in this house that they had a mortgage on due to whatever situation, very likely arrears. They may have moved out back into a family home and rented out the property. They would have rented out this property as much as anything else in order to meet the arrears, just to keep up with their financial obligations, with the hope in the longer run perhaps that they might be able to move into it. But because that they are renting this out, it is possible to bring in the receivers, and because receivership being a different process, it is I suppose it is possible to appoint a receiver without the same court procedures that might apply for a repossession, that they don't have to go through the repossession process and the additional protections that have been created in that regard so far, and in this legislation and everything that goes with it. So that is the kind of case that we are proposing, that applications for receivership in those instances should come to the Circuit Court. I think it's, as I say, very often these are people who are trying to do the best they can to stay up with the mortgage and want to get the house back. That's what they want to do. But there is a backdoor there that has been created, and it's not so much maybe the traditional banks, but some of the other financial institutions that are using this. And I think those people need protection, and that's what this amendment seeks to do. The final amendment that's there is, and Deputy Caoimhghín has dealt with it, is retrospectivity. The Minister maybe can try and clarify this, but it's not immediately clear that this applies retrospectively. I think it has to. It has to be the case that the tens of thousands of mortgages that are in arrears, people who are very worried about repossession, I'd say the very same people that you were thinking of when you were pushing this bill, Minister, that they are very worried about repossession. They deserve the maximum protection. The amendments that I and Deputy Caoimhghín have put down seek to ensure that that is crystal clear, to put a sound legal basis for those people in this legislation. I take generally a different view from Deputy Caoimhghín in relation to the amendments. I communicated that to you a short while back. I accept the point that's there. I don't feel any desire to delay this legislation unduly, but this is how the legislative process works. If there are, I suppose, we have a discussion, we put down amendments to try and strengthen the bill. I believe that these do strengthen the bill. If it is delayed subsequent to that, I believe that that is a matter for government and your government colleagues if people decide to try and slow it down at that stage. But I think that these are good amendments. I think they're worth being in the legislation, and consequently I will be pressing them. Thank you.
Thank you, Deputy O'Leary. Deputy Chambers, please.
Thank the Minister for coming forward. So I just want to ask, there's mention of delays and the potential implication of amendments. Without delays, when do you expect the legislation to be commenced? Can you give an indication on that?
Fairly shortly. To get it back into the Dáil. I would, and I stress to the members of the House, and I spoke in the Dáil, that it took 3 years to get this bill to where it is today. And I fully appreciate the amendments that's put down in front of us. But for the tens and thousands of people out there that's campaigned, and trust me when I say they're on your door, the same as my door, for this to be delayed to add on a piece of legislation, we're in a minority government. We don't know where we are, what's going to happen next. For this piece of legislation to get an act could be done as quick as before the summer. And by delaying this, by going back to for the legal people to get their opinion, could really delay this bill, and we may never see the light of day. And for the people out there that are asking us as legislators, this bill goes along with helping those people. I respect what the Deputy is saying, but it's something I think that we should look at.
Just on that, because I know you had to get an opinion, I think, from the ECB, isn't that right?
Yes.
So if any amendment was made, would that have to go back to the ECB again, or is it through the Attorney General to see if it has to go to?
It may.
It may.
It may.
Okay.
All right, Deputy, thank you. Minister, would you like to respond to the members' contributions, please?
In relation to the government is opposing these amendments, the basic objective of the bill is to propose added protection for the people in mortgage arrears, with respect of their principal private residence. This amendment will not help such people in any way, for the simple reason is that the receivers are not appointed by the principal private residence. The receivers are generally appointed to buy-to-let properties for the purpose of the ensuring that any rental income in the property is used to service the mortgage. In this case, the principal private residence, there is no rental income, so the appointment of a receiver would be in no benefit to the lender. Receivers may be appointed to buy-to-let premises, however, on which there is a house loan mortgage, where the borrower continues to collect the rental income but is not using the service to service the mortgage. The appointment of a receiver in such case would fully justify, for the same reason that the receiver may be appointed to receive rent in the case of other commercial properties. It is not clear to me why the borrower in such circumstances should benefit from the additional protection set out in the amendment. The rationale behind the proposed amendment appears to be that it would assist certain borrowers who, for whatever reason, rent out the principal private residence with the view to serving the mortgage. I feel that I should point out that such an action in itself is a breach of the mortgage contract. However, said that, I have to say that it is not clear to me how often this happens. It is, however, clear that the proposed amendment would cover all instances where the lender decides to appoint a receiver, which would include all buy-to-let mortgages. This would invariably cause difficulty for the court service in terms of the demands on the court time and the cost of processing the application for the court orders. Recent figures from the Central Bank indicates that receivers have been appointed to over 5,600 buy-to-let mortgage accounts, and approximately 300 receivers are appointed to such accounts every quarter. Requiring lenders to apply for a court order prior to the appointment of a receiver would lead to an increase in demand in terms of time and cost to the court service. It should be added that, apart from any statutory power to appoint a receiver, mortgage deeds normally reserve a contractual right for the mortgage to appoint a receiver when the conditions such as those in section 108(1) are satisfied. The amendment seeks to set aside terms that may be contained in the mortgage agreement contract, and I could lead to a legislative challenge. If the amendment is passed, the Minister has indicated that it will be necessary to obtain legal advice on the matter prior to report stage, which would delay the passing of the bill. That's why we're opposing the amendment.
Thank you, Minister. Deputy O'Callahan, once again, in relation to Amendment 1, you're withdrawing?
Correct.
Yes, Deputy O'Leary.
Can I ask the Minister to clarify just your remarks? Are you saying that as things stand, it would be a breach of the mortgage terms to, am I understanding it correctly, right? There is a breach of the mortgage terms to have somebody in the property other than the mortgagee paying rent to, I'm not sure if I'm using the right word there now, to the person who has the mortgage, right? Paying rent, that they are renting it out, and that rent is being used to pay the mortgage. You're saying that that's a breach, and
It is a breach.
that's a breach. Okay, all right, okay. And are you saying also that, I suppose, in circumstances where that's happening, whether it's a breach or not, it's not possible to appoint a receiver? Did I understand that correctly as well?
Yes, it is, yes, and it also stresses out that these people are in breach of that. Look, we can all fight and look at it all day long, but when you go into a contract with a mortgage and with your bank, like, you have to honour that contract as well. And as I said in the outset, I don't know many cases where that's happening, but it may be happening in some cases.
Yeah, but surely if there was agreement with the borrower, like, I don't know how it would be. I don't quite understand how it would be failing to honour the mortgage if you've, by agreement of the borrower, that you have somebody in there, they're paying the rent and the mortgage is being paid, or a large chunk of the mortgage is being paid at any rate.
Well, there are different terms, Deputy, in relation to mortgages, and you know that as well as I do, and it sets out quite clearly it's in breach in relation to contract.
Okay. We're not going to be able to shed any further light on it. I mean, there we are. Amendment 1 has been withdrawn. I propose to move on to Amendment 1A. It's already out of order, so that can't be taken. Therefore, all the amendments in Section 1 have been addressed. The question is that Section 1 stand part of the bill. Is that agreed? Caoimhghín. Section 2, Amendment number 2 in the names of Deputies Ó Caoláin and O'Leary is out of order, as has already been advised, so therefore that cannot be taken. Amendment 3, which represents a new section, the names of Deputies Ó Caoláin and O'Leary, already discussed with 1. Can the deputies please indicate in both their names where stands the amendment?
I'm not pushing the amendment.
You're withdrawing?
Yeah.
I press the amendment, yeah.
You're pressing the amendment?
Yeah.
So the amendment, I presume, is a composite, that it didn't go in both your names?
Yeah. Okay.
Composite. Okay. In that case...
Delegate, I'll be abstaining.
We have established that the amendment has been pressed by Deputy O'Leary. On amendment number 3, the question is that the amendment be made. Those in favour say "Tá." In this instance, Deputy, you're not in a position to actually vote.
Okay.
So on your behalf, I will record a "Tá."
Right. You're very generous.
Those who opposed, please say "Níl." I think the question is lost. The question is lost. There are no other amendments to Section 2, so therefore I put the question that Section 2 stand part of the bill. Is that agreed? Caoimhghín. We're moving on to Section 3. We have I beg your pardon, we have 2 amendments in Section 3. 4 and 5, these are grouped. They will be taken together. They're in the names of Deputies Ó Caoláin and O'Leary, Amendment 4, and Deputy O'Leary alone in relation to Amendment 5. Now, I have it to say that if the question on 4 is agreed, 5 cannot be moved, just for the information of members. Deputy Ó Caoláin, you're the first name on that listing.
Yeah. I'm withdrawing the amendment.
You're not proceeding.
Yeah.
Deputy O'Leary, where stands the amendment in your case?
Speak to this group.
You have, of course, the right to speak to it, yes, 4
Okay.
and 5 combined.
Very well, yeah. Look,
They'll be taken together.
5 is probably less comprehensive than 4. I would prefer 4. Look, I mean, I suppose the purpose of this, I've spoken to it already briefly in my initial remarks. The purpose is very simple. We want to ensure that all existing cases where there is people in mortgage arrears are covered by this, because it's not immediately clear to me on my reading of the bill, and I'm not known in this, it seems to be the view of FLAC as well, and obviously to some extent maybe the view of Deputy Ó Caoláin, that these are not necessarily covered. So I suppose that's why this amendment is there. I will ask the Minister, I'm likely to press it anyway, but I'll ask the Minister, are you absolutely certain that existing cases are covered by this legislation?
Minister, would you like to reply, please?
Okay, the government is opposing these amendments. The intention behind the amendments is unclear, but may arise from the desire that the bill should have respectively effect to that end. The amendment proposed the insertion of its own words, any proceedings brought by the mortgagee, irrespectively of when the mortgage was created, into the subsection. I consider that the amendment is unnecessary, since it is clear from the current wording that the section applies to any and all proceedings brought by the mortgagee for the possession of land or to which Section 2 applies. The amendment adds nothing on the contrary by depending from the existing wording departing from the existing wording in subsection 2 of the Section 2, it seems to suggest that the range of mortgages of which Section 2A applies is somehow wider than the range under Section 2. There is a danger that the amendment will create uncertainty in relation to the scope of the bill. The current wording is consistent with the wording in Section 2.2 of the 2013 Act, and the amending of the provision in the manner suggested by the amendment could create confusion as to the scope of the existing Section 2.2 of the 2013 Act.
Wish to add anything further?
Okay, I suppose, yeah, look, I mean, I'd ask the Minister, I suppose, just to be as direct as you can, you're certain that all cases, existing cases, are covered by this legislation, because it seems to me on the wording that, as I see it, that it's open to challenge by financial institutions saying, no, this doesn't apply. This is only for cases that arise in the future, especially given that legislation, generally speaking, applies to cases that arise in the future. There is a tendency against retrospectivity. I think that's desirable here. I'd appreciate if the Minister can clarify it as best he can, but yeah, I'm not confident in the wording myself.
No, but this bill applies to all mortgages covered by the 2009 and 2013 Land Conveyancing Law Reform Act.
Okay, Deputy. Where stands amendment number 4?
Pressed.
You're pressing?
Yeah.
Okay. In that case, it's been established that the amendment has been pressed. So, on amendment number 4, the question is that the amendment be made. Éideann a bhóbhar aber tá. Éideann a gunne aber níl. I think the question is lost. The question is lost. We move on to amendment number 5, also in the name of Deputy O'Leary. Already discussed with 4. Where stands the amendment, Deputy? Pressing? Yes, but that would only be in the event of 4 having been passed. So, Deputy O'Leary wishes to press his amendment number 5. On amendment number 5, the question is that the amendment be made. Éideann a bhóbhar aber tá. Éideann a gunne aber níl. I think the question is lost. The amendment is lost. There are no amendments, therefore, to Section 3 as it stands. So the question is that Section 3 stand part of the bill. Is that agreed? Caoimhghín. Section 4, there are no amendments. The question, therefore, that Section 4 stand part of the bill. Is that agreed? Caoimhghín. That concludes address of the amendments. The title. That this be the title to the bill. An Act to amend the Land and Conveyancing Law Reform Act of 2013 to provide for the procedure to be followed in certain legal proceedings to which Section 2 of that Act applies and to provide for related matters. Is that agreed? Caoimhghín. Consideration of the bill has been completed. In accordance with Standing Order 90, the following message will be sent to the Clerk of the Dáil. The Select Committee on Justice and Equality has completed its consideration of the Land and Conveyancing Reform Amendment Bill 2019 and has made no amendments thereto. I again thank the Minister of State and his officials for attending here this morning and the members for their cooperation. The Select Committee is now adjourned until 9 a.m. on the 27th of June, when it will take committee stage of the Gender Pay Gap Information Bill, and there will be a full attendance because Deputy Brophy will be in the chair. And I wish him every success. Caoimhghín.